Wonderful. So I am the Dean of the Harvard Law School, and it is just a tremendous joy for me to welcome people here. I know people are going to be coming in and out because classes are going on, but this is really a Dersha Fest or Dershathon in honor of Alan Dershowitz's 50th year at the Harvard Law School. I think we should all give some applause. The Harvard local newspaper recently described Alan when he arrived here as enfant terrible, and now he's eminent grise. But somewhere between those two, he is the most beloved, most outrageous, most provocative person that I think I've ever encountered. And it is just with great, great delight that I turn these festivities over to Professor Noah Feldman, who will chair the first panel discussion. There will not be a lot of time, and so we're just going to move along, particularly because we want to make sure that Alan gets a chance to talk. So, Noah.
Thank you, Dean Minow. Good afternoon, everybody, and welcome. This is a great honor for the Harvard Law School, and I'm especially pleased to have the chance to participate myself. I will restrict myself to a single Alan anecdote, which is that from the time I was a very small child, growing up about a mile and a half from here, my parents made it extremely clear that there was one person in life whose professional goals one should emulate, and that was Professor Alan Dershowitz. And the main thing in life was to just sort of follow that lead and just keep on going. So I've been trying, and it's a great honor to participate today. This is literally the dream team of all panels. To say we have one president of the Israeli Supreme Court would be a matter of great pride. To say we have two is, frankly, astonishing and certainly unprecedented in the history of this law school, and very possibly it would be a rare thing even in Israel. In addition to that, I have a beloved colleague, Bob Mnookin, my dean, Martha Minow, and Professor Akhil Amar, who actually was the person who taught me constitutional law first, and who I therefore have the respect that one must have for a rabbi. So, as a consequence, this is really quite an opportunity to hear a really diverse and interesting set of views focused on Alan's scholarship in particular. We'll hear later about his roles as public intellectual and as public figure. This panel is focused on Alan's scholarly work, of which there has been an enormous amount that has continued unabated throughout his career on a range of fascinating subjects. I will make my introductions extremely brief, and I'll do them in the order in which we'll hear from our panelists. This is in inverse proportion to the importance of my fellow panelists. So let's begin with former President of the Israeli Supreme Court, former Justice Aharon Barak, who served as head of the court from 1995 to 2006. And please, yeah. Professor Barak has, as you all know, been a transformative figure both in Israeli law and constitutional law and internationally in constitutional law. He spends much of his time now at Yale Law School, and we're very, very pleased to have him. He will speak first. Next, and I'm going only in chronology, not in any other order, is immediate past president of the Israeli Supreme Court, Justice Dorit Beiniesh. Who followed Justice Barak and served from 2006 to 2012 as president, having previously served for years as a serving justice. She has also had an enormous impact on not only Israeli jurisprudence, but also on the international space of comparative constitutional and law, other aspects of law. And she is now spending some of her time at the NYU Law School, another institution which I love very dearly. Next, we will hear from my colleague, esteemed colleague, Professor Bob Mnookin. Many of you in the room know Professor Mnookin. He's been a colleague of Alan's for many years here. He's the leading figure in law and negotiation, and his recent book on bargaining with the devil is a book with which I think Alan didn't entirely agree, but it's a topic on which I know Alan has a great deal of interest. And then to my left, Professor Akhil Amar of the Yale Law School, an extraordinarily distinguished professor of constitutional law, who has had a vast generative impact on constitutional scholarship in this country and beyond, and it's an enormous honor to have Professor Amar here today. And last but not very much not least, our dean, Dean Martha Minow, who has mentored me from the time that I was a recent graduate of law school until this very day. And anytime I get to introduce Martha, I like to say that she models what it is to be an intellectual who also knows how to run things. And since James Madison, I'm not sure there have been too many people who could do both. Martha can do both, and we're extraordinarily fortunate that she does on all of our behalfs. So without further ado, Justice Barak.
Thank you. So this panel is about scholarship, but I can't talk about scholarship without talking about something which is more important than scholarship, and that's friendship. So I came to Harvard in 1966. I was already after my PhD. It was a postdoctorate program with Elika, my wife. And all the people that you know from Harvard were around. The dean was Griswold at that time. It was a cold place, let me tell you. I had very few friends. So some of the young people, Charles Fried was a friend, and Frank Michelman, this were youngsters. Paul Freund was still around, Louis Loss was around, but they were another generation. But there was one guy who was so warm. Friendship, truth, and that's Ellen. And Ellen, I will never forget it, never. We took together classes. We had Henry Hart, legal process, as a seminar for graduate students, or for teachers, rather. And we met many, many times at their place, at our place. And since then, Ellen is my best friend on earth. And I'm so happy to be here. Now, another friendship is, as you probably know, the Supreme Court generally, and myself specifically, and Dorit, of course, too, we were attacked tremendously by the Israeli press, by the Israeli public officials, etc. And the Israeli academia was not so supportive. But there was one academician that came to Israel and supported the court a lot, and that was Alan. Though he was a foreigner, but his voice was heard and people listened to him. And it was very important to the court. And of course, the third point, Alan was very important in defending Israel generally. I think this may be another topic that will be discussed here. But I'm so proud to tell you that his book, The Case for Israel, was dedicated to me. So Alan, it's a long time. About Alan's scholarship. So his books and his articles were cited by us judges on the court heavily. I have a whole pile of cases in which his books, mainly his articles, were cited both for purposes of extending rights and for purposes of limiting rights, whenever limitation of rights was important. Alan started to write about law and terror much, much before September 11. So it was not so relevant here, but it was very relevant at home. You had September 11. We had September 10, September 12, September 13, and we have even now, what is today, October 7. So you have it all the time. And so it was on our mind all the time. And things that Alan wrote really were guiding our thinking, the judiciary thinking, on how to deal with this phenomena of terror, especially those terrorists who are ready and willing to kill themselves just in order to perform their function. And so prison sentences, etc., don't make any difference for them. And so Alan was writing about torture much before you became interested in torture. I remember I was teaching both here and at Yale on torture. No one was interested about that. But Alan was, and I was, because I think my judgment on torture was given at the end of the 90s, in which we decided, the whole court, that the government has no authorization for torture, point. And at home, it was a very important, I think, decision. Outside, it was, nice, it's irrelevant. America will never torture, so what are you talking about? Well, America tortured. And those things that we wrote in our judgment and that Alan wrote in his judgments suddenly became quite relevant, very relevant. And let me say just several points about torture, because here we have a lot of agreement and regrettably a lot of disagreement. Our agreement was that the idea that, okay, let the government torture, and when it will be over, then we'll deal with it somehow, kind of Posner idea about it. The Constitution is not a suicidal pact, so let's do what is needed, and later we will. Also, Lincoln was not following the Constitution all the time, and later it will be solved. Alan disagrees with it because he is a rule of man law. A rule of law man, not a law of rules man. And same thing was my view. You need a legal norm to start to think about torture. But here we split. Alan was writing about warrants that judges will issue that will authorize torture. I have never encountered this question. As I mentioned, we decided that torture is, that the government has no authorization for torture. What was in back of my mind, in addition to the legal analysis, is the bureaucratization of torture. This was my main fear. And out of hundreds and hundreds of torture cases, maybe one is a ticking bomb situation. But one case there may be. And the split between Alan and myself, which was presented in the judgment I wrote about torture, was that I raised the possibility, maybe, well, I said there's no authorization for torture, but I raised the possibility that maybe if torture is exercised by a public official under a ticking bomb situation, maybe he has a defense of necessity. Alan said, no defense of necessity. And maybe he's right. So what was my theory? His theory was, go to the court, get a warrant. My theory was, no, the court has no authorization to give a warrant. This was our situation. You don't have any authorization at all. Torture is wrong. You can't torture, and there is no authorization for that. Yes, but I am on the spot. I can prevent September 11. Well, my theory is and was, it's a personal decision that you should take. You are with yourself. The state is not behind you. There's no authorization. And you should take the decision. No bureaucratization. And if you think that the right thing to do is to use torture, then be prepared to pay the price. And the price may be that you made a mistake. It's not a situation of torture, and you may be prosecuted, etc. And if there is a necessity situation, I raised the possibility of necessity. I was not in favor, I was not against. I just raised this possibility. But what stands in the bottom of my theory of dealing with torture is, under the existing laws, we had it in Israel, not to make torture something which a higher official authorizes a lower official. To make the torture decision a personal decision of a human being, whether he's a public official or he's not a public official. If he's not a public official, even Alan would agree that he may have necessity defense. If he's a public official, Alan said no, I left this thing open. But what is in the center of my idea was this, that it must be something that you take personal, moral responsibility. And let me tell you, and I'll finish with that. A year after I gave my judgment on torture, I met the head of the Israeli torture, or the Israeli authorities dealing with security. And he told me, you know, Aharon, because I, in my judgment, expressed worried. The bombs were blowing in the streets, and I was worried about the defense of Israel. He said, don't worry, we learned a lesson. When we use our head, we have better results than when we use our hand. And you know, on my last day in the court, I was sitting, it was already over everything. I was sitting with myself in my chambers. This is a court on which I was sitting 28 years, so it's a long time on the court. And someone knocked on the door and told me someone from the security forces wants to give you something. Well, I said to myself, a bomb? What is he going to give? No. It was not a bomb. It was an envelope. And in the envelope, there was a facsimile of a cable. And the cable was issued 2 hours after we rendered the judgment that there is no authorization for torture. And the cable said to all the people in Israel, to all the officials in Israel that do investigations and that are using torture, stop, because the Supreme Court said stop. And he gave me this facsimile. Could a judge given a better gift? No, it was the most wonderful gift I got from them and much from Alan. Thank you.
Justice Barak, thank you very much for starting us with such substance and such importance. Justice Beiniesh, the floor is yours.
Minow, members of the panel, distinguished guests, family of Alan, friends, and of course, dear Alan. It is a great privilege for me to be among this distinguished panel of academics and to have the opportunity to honor the diverse and influential work of you, Alan, Professor Alan Dershowitz. The truth is that I can't speak, as Aharon said, no one can speak about your work. It will take weeks, months, and we have 10 minutes. But I want to thank you, to express my gratitude for your contribution to the defense of human rights, values of democracy, for all that you contributed in this great work that you have done as a teacher, as an academic, and you had the rare opportunity to apply to the legal practice your ideas that you developed as a scholar, which is not everyone has this kind of ability and success. And I want to say also as a personal, first of all, of course, I'm so grateful for what you did, for in a fierce advocacy for the just case of Israel. This was so important. This is still important. You still do that. And it's unbelievable. This is all one man. Some people know you, Alan, as a rival. But I think your many friends know you as to be the true and loyal friend, a real mensch. And I think this, as Aharon already mentioned, the most important thing. And I want to thank you for your friendship. In his work, Alan correctly identified a transition from the traditional model of deterrence and punishment to a stance emphasizing the prevention of harm caused by crime and terror. This move entails a heightened risk to human rights. In the short time that I have, I wish to briefly touch on 2 issues relating to our ability to safeguard against potential governmental abuse in the fight against crime and against terror. The first has to do with the exclusionary rule. where I don't accept your sweeping rule. And the second is to do with the use of torture in the case of a ticking bomb. And here I think I'm somewhere between what you think and, of course, what Aharon now described. The topics may initially appear unrelated, but one can detect a deep connection that binds the two. The views on both issues are often informed by an attitude of distrust towards governmental authorities when they operate to achieve the goals of crime and terror prevention. I want to suggest that in order to ensure the accountability of governmental decisions in this regard, in both cases, we need to opt for pragmatic institutional arrangements that will enhance our ability to entrust decision makers to begin with, while allowing for the judicial review of their actions ex post. When it comes to the exclusionary rule, I believe that the decisive factor in excluding evidence is the violation of the right of a defendant to due process. Unlike Alan, I accept the distinction between technical or marginal errors and substantial illegality and violations of rights. The distinction is embedded, I must say, I want to quote our first president in his first decision of the court in Israel, the first, 148, when he said, and I quote, "The criminal trial shouldn't adopt the form of a game of chess in which one wrong move determines the result of the game." So only a few years ago, we introduced in our judgment the exclusionary rule. We had a different system, of course, the old British free and voluntary confessions. And I believe we were closer to the Canadian solution, maybe the British. A sweeping rule of exclusion frustrates, in my view, the important aims of the criminal process, which in addition to the rights of the defendant and the fairness and integrity of the process also include the discovery of truth, the fight against crime, the protection of public safety, and the rights of the victims. Here, similar to other areas of the law, the court must have the ability to balance and exercise discretion in considering the character of the violation of defendant's rights against the circumstances. A discretionary exclusionary rule trusts the ability of judges to apply strict scrutiny to the work of police and other enforcement agencies and recognize those situations in which defendants' rights were violated in a way that adversely affected the criminal process and our sense of justice. I truly believe that this approach does not encourage violations of the right to due process, but rather strikes a better balance between the various goals of the criminal justice system. The second topic that I wanted to address is the torture and the necessity defense. Well, as it was so, of course, thoughtfully and profoundly and with a lot of really time and thinking that my teacher and colleague, President Barak, already talked and thought so much about it. I will limit myself to a suggestion regarding the institutional accountability in this matter, which I believe also coincides with the analytical framework of the necessity defense. My suggestion is informed by my own experience, I must say. Unfortunately, I had to confront those issues many times as state attorney and, of course, as a judge. I agree that considering the alternatives, necessity is the best available legal mechanism to deal with the extreme situation of a ticking bomb. For the necessity defense maintains the notion of torture as a strictly prohibited practice. However, we are all aware that the criminal defense itself was meant to address a different factual scenario, and you, of course, wrote about it. The difficulties involved in transferring the doctrine and principles of necessity to these very rare and extreme circumstances of an institutional invocation are rather obvious. I must add, it is true that after this great judgment of President Barak, I know that in the security service, they really stopped practices of torture. They really did. But, of course, even in this judgment, it is mentioned, we have the very rare situation of a ticking bomb. And we cannot be naive, it happens in those very rare situations. So there are many difficulties. I don't think that there is a good solution. One such real difficulty that Alan has expressed his concern about while operating under harsh security demands and public and governmental pressure to prevent terror, civil servants may find themselves with no legal compass to guide them in extreme situations, with no authorization, which is the most worrying, to act, and with the fear that they will later face criminal charges. One solution to such difficulties is to draw clear guidelines which will define the circumstances that constitute a situation of a ticking bomb and the means that are allowed in such situations. I, of course, agree with President Barak. We don't accept it, because here lies the danger of ending up with a torture manual and the legitimation and expansion of the use of coercive means in the service of interrogations, and we cannot accept it. A different solution was offered by you, Alan, what you call the torture warrants. This idea provoked much criticism, and to my mind, for good reasons. I wanted to elaborate on it, but I think everything was said already. What is the danger in those warrants? Our basic intuition as legal people is against a warrant by a judge and legislation. And if I think of myself, I don't think I could issue such a warrant if needed. And we don't have such good experience. We hear now about the surveillance warrants, and I'm not sure everyone is happy about that too. So my own suggestion is to adapt the criminal necessity defense to the very special circumstances of the institutional use of the defense. In the renowned judgment of the Israeli Supreme Court, written of course by Aharon Barak, the court takes a first step toward the adoption of recognizing it as a possibility, not for sure, the interpretation of the criminal defense requirement immediate need, as satisfied even that the bomb is set to explode in a few days or even a few weeks. I am ready to take another step in this adaptation of the process. The assessment in a ticking bomb situation that there is immediate need requiring the use of special means should be taken, in my view, by a person who is best equipped to make this decision considering the overall related intelligence. That person does not have to be physically present in the interrogation room, conditioned that he or she closely accompany the interrogation and can monitor its progress if present, as if he is present in the room. That person is the one to be held responsible for the decision. In most cases, this person will be the head of the security service and not the individual interrogator in the interrogation room. After the fact, the decision and its results should, of course, be subjected to legal and judicial review. The necessity defense will apply to the decision maker. Obviously, if the decision will be found manifestly unlawful and does not merit the necessity defense, the interrogator will also be held responsible criminally. He cannot, of course, if it's an unlawful order, so he will be responsible for that. I acknowledge that this is not a perfect solution. I don't believe there is one. It is preferable because it allows the system to maintain its value integrity on the one hand and foster the inter and inter-organizational culture of accountability and transparency on the other hand. I take it that the solution does not contradict the basic concept of using criminal defense as the framework of exceptions in extraordinary situations. We preserve the rationale behind the defense of necessity, but extend it to the most suitable person to make such a decision and bear the responsibility for it. By preserving the framework of a criminal defense, we safeguard against fear that ex-ante legislation, guidelines, or warrants may legitimize torture's means. And that's why I think we cannot accept the warrant theory. On the other hand, this mechanism supports an organizational culture of truth. As I have learned from personal experience, interrogators dedicated to public service are very concerned with the legality of their actions and often seek guidance. The possibility of a vacuum which leaves the decision in the hands of every interrogator may not only expand the number of cases in which torturous means will be used, but also lead to the development of an organizational culture of lies or cover-ups due to the fear of possible criminal charges. In contrast, placing the responsibility for the decision in the hands of the head of the agency would encourage openness within the organization and towards the other authorities, as it will release the individual interrogator from the motivation to lie. Alan, even I reject some of your ideas and some of your solutions, I admire your constant and frank efforts to promote the ideas you believe in. I'm sure that your retirement will not change your commitment to fiercely promoting the value of democracy, human rights, and betterment of society, all in good health. Thank you.
Thank you, Justice Beiniesh, and thank you for introducing yet another new, I think, original theory into the conversation. Alan, it says something. I think this would not be true of anyone else in our academy, that the first two speakers at the conference in your honor actively disagreed with you, and that you were happy throughout the entire engagement. Very, very good. We're off to a good start. Bob, please.
Well, I'm now going to agree with Alan, and I'm not going to talk about his contributions to criminal law or human rights, nor am I going to talk about his defense of Israel. I'm going to talk about his scholarship, which I view as addressed to the American Jewish community. In particular, his marvelous book, The Vanishing American Jew. I have to start with a small anecdote. When I came back to Harvard Law School in 1993, Alan and Carolyn very graciously welcomed me. And in the years since, we've seen each other a fair amount, especially in the summers on Martha's Vineyard. And shortly after my arrival, I've got to do one thing to correct the record, which I never did. Alan said to me when I arrived, he said all kinds of extraordinarily flattering things about what I was like as a student and how I was one of his favorite students. I didn't have the courage to tell him then. I never took a course from him. I wish I had, because he was here, but first-year courses were assigned. Alan's book, The Vanishing American Jew, which was published 15 years ago, deals with a question that, as he acknowledged, a man named Simon Rabinowitz characterized as Jews being the ever-dying people. Every generation of Jews thinks it's going to be the last. And because I'm now working on a project relating to negotiating Jewish identity in America, I was especially interested in this book, and I found it stunning just how much he had already said, and as I struggled to figure out what more I was going to be able to say. What this book emphasized is something most are very well aware of, and that the success of Jews in America, the decline of anti-Semitism, the enormous growth of intermarriage, indeed, the most recent study, which I read over the weekend, this Pew report, which some of you have probably read about, indicated that of Jews married since, I think it was 2000, let me get the exact number, I don't want to misquote it. Of those married since 2005, something like 70% are intermarrying. In reading this book, I came to this issue from a perspective that couldn't have been more different than Alan's. Alan grew up in Brooklyn, where he went to a yeshiva before he went to Brooklyn College, where he describes his own modern Orthodox upbringing as requiring following the rules. And in fact, he's come some distance since. I mean, he's now a self-declared secular Jew who acknowledges, he says in his recent memoir, that he only goes to synagogues, maybe a dozen times a year. I would also challenge that fact, because if you count the speeches he gives to brotherhoods and sisterhoods, I would say he probably goes 50 times a year. But I think if we're talking about religious observances, that's probably right. Well, I grew up in a Kansas City Jewish family. Both my parents were born in Kansas City. All four of my grandparents lived there. I went to a private boys' school that, when I was growing up, had a quota for Jews. And my grandfather, in 1925, had bought a house in what was called the Country Club District, and he had to buy it through a straw. And one of the themes that, Alan certainly identified in his book, which is absolute, it's even more true today, is I think today in America, and I know that for some this may sound that I'm going too far, but I think there is no social, economic, educational barrier to an American Jew identifying as a Jew. And I can give lots of anecdotes. I'm not going to bother to demonstrate that's true. But during my lifetime, much less my parents' or grandparents' lifetime, there has been a remarkable change. Why has intermarriage gone up so much? Because, in fact, one important reason is that because American Jews are so much more tightly integrated into American life generally. A second reason, of course, has to do with something the Pew Report demonstrates, and that is, and it extends much broader than just Jews, and that is the decline in the importance of religion, of the Jewish religion as a religion, especially to Jews. This is also very true of mainstream Protestants. And Jews as a group in America are much less religious than other denominations. And I think that as a consequence, there is neither the external push to sort of maintain the tribalism, nor does the religion necessarily provide the glue for many. And I think that what many of my generation and my children's generation really ask ourselves is, other than the Orthodox, where they're going to survive, and there'll probably be a vibrant Orthodox community in America, what's going to be the case in terms of what Alan would call secular Jews in terms of 50 years or 75 years in America? It's much harder to say. Alan's book proposes three possible answers. One is religion and a return to religion. That's, of course, you can look at history, and there are religious revivals. I'm deeply skeptical that that's very likely to happen. The other answer is Israel, make Aliyah. I think, in fact, for most American Jews, some American Jews will, of course, go to Israel, including some who are secular, but for most, that is not the answer. They feel much a part of American life. And I think that the other answer that he explores, which I think is a fascinating one to think about, is how one can, that means my 7 minutes are up, so I'm going to finish up. If I can turn this thing off. How can, in fact, the tradition of a variety of values, which I think American Jews identify very much with their Judaism, how can these perhaps provide a foundation for building a more solid identity? These values have to do with the quest for justice. They have to do with tzedakah. They have to do with peacemaking and healing the world. And I think it is my own hope, and I think it's Alan's hope too, that in fact the pursuit of these values might make America safe for secular Jews as well. Thank you very much.
Thank you, Bob. I should say, in reintroducing Professor Amar, that not only is Professor Amar a leading scholar of constitutional law, but he's also got a sideline as a leading scholar of criminal procedure, and I think it's probably primarily in this capacity that he's here today. I see two of his books here, one on the Constitution and criminal procedure, which spans the two directions, and the other, America's Constitution, a biography, which everyone should read, just because everyone should read it, and I don't know if Akhil will talk about that now, but Akhil, the floor is yours.
It's such an honor to be here, Alan, as your a friend and interlocutor on this extraordinary panel. This is a panel devoted to the scholarship of Alan Dershowitz. This is a man who's written dozens, and that's a literal truth, of books, not articles, books. And we've only begun to talk about the range, but we've already heard about the case for Israel. We've heard about torture warrants. We've heard about the exclusionary rule. We've heard about American Jewry and the Vanishing Jew. And I'm going to talk about something different still. I'm going to talk about one, I thought actually this was maybe his most recent book. Ella corrected me that this was probably 5 books ago. And I can't keep up. He writes faster than I can read. And I'm, not a slow reader, but I'm going to talk about self-incrimination. Is there a right to remain silent? A spectacular book, a really interesting book. I can't resist reading to you, because this is very meaningful to me, the inscription that Alan wrote to Akhil, who always inspires me, even when we disagree, which we rarely do. Keep doing great things, best, Alan. To which I say, right back at you, big guy. I do disagree with some of this, and I'm going to share that because as you've already begun to hear, you have in the persona of Alan Dershowitz this amazing combination of friendliness and feistiness. He likes people to disagree. He wants to bring them out, and people aren't, and his true friends aren't afraid to say, yes, but, I'm not so sure. And in that spirit, I'm going to offer a few thoughts because Alan, you're not done yet. There's still some books left in you, and I've got some ideas about what I'd like to actually see, because you're not yet in triple digits. You're in the dozens, and actually, yes, the reason actually I brought these two up here is I've only written 4 books, and on 2 of them, Alan Dershowitz's name appears as a blurber. And my criminal procedure book in particular was one where he disagrees with my vision, and frankly, so do most folks in the field of criminal procedure, and no one else representing kind of the orthodoxy that I was critiquing, in my view, treated me remotely with the kind of generosity and fairness that Alan did. He saw that there were some ideas here, there were real ones, they weren't his, and he reached out to engage them in a way that no one else in the field did. So that's why I brought them here, not for self-promotion. And actually, the other one, his name, so that one, his name appears in the paperback because I didn't think he actually reviewed the book. And the other one, he was a blurber. And by the way, Noah gave me the subtitle to that book, a biography, which I think doubled the sales. So thank you, Noah, for that. I want to talk about self-incrimination. And this book, Right to Remain Silent. Let me sketch out for a minute or two my outlandish thought. Alan disagrees with it, and I want to identify, I think, some interesting opportunities for him to write yet another book on the topic, or maybe 2 or 3. The text, we always start with the text, right? You'd be disappointed if I didn't. This is the Fifth Amendment, or in relevant part. No person, ... shall be compelled in any criminal case to be a witness against self. My thought is, the core of the right is actually a right of a defendant in a criminal case not to be forced to take the stand. And Alan says, well, that can't be the core of the right because no state allowed that at the founding. And I said, yes, it was declaratory. Actually, it was confirmatory of existing practice, and we want to work out from that and see what the deep principle is, and we might need to expand beyond it. But it's not actually weird to think that the core of a right is merely declaratory, just like the 10th Amendment is affirming something that pre-exists. So why do we have this right? And in the process, what does it mean? My thought is, well, we have this right to protect innocent people from erroneous conviction. Someone might be completely innocent of the crime that he's charged of, but he might stutter, he might sweat, he might look guilty, he's not law trained, and the prosecutor can slice and dice him, the clever Dostoevsky interrogator, and make him look guilty, even if he's not. And there's a distinctive cruelty if he's actually hanging himself by his innocent and by his truthful testimony of his own innocence. Now, if you see that that's the idea, you can say, well, of course, he not only has to have a right to take the stand on his, to decline to take the stand, but if he's given the option, there should be no adverse inference. So that explains because maybe he's not taking the stand because he's a stutterer, and of course we can't allow the trial to just recess for 30 minutes, and the jury and the judge and the prosecutor and the defendant all walk across the street, and then they put him under oath and have the jury see all this and then come back. And of course, we can't have the police force him to talk under interrogation the day before the trial formally opens, and then introduce that affidavit, and we can't even do it in the police station. All of these forms of testimony, of witnessing outside the criminal case, can't be brought into the criminal case, but as long as we exclude his testimony from the jury itself, he never will have been made compelled to have been a witness against himself in the criminal case within the relevant meaning of and purposes of the rule. Now, is this the only reading of the text? Not at all. You could read the words witness differently, criminal case differently, but I thought it had certain advantages. The most important which was I thought it actually offered a truth-protecting, innocence-protecting account of the amendment, and it actually also, whereas conventional accounts, including Alan's, which exclude not just words that are spoken outside the courtroom if they're obliged by the police, but fruits that are derived from the words. So we ask someone in the police station, did you do it? And he says, yes. Where's the body? And he tells you, and they find the body, and it's got his fingerprints on it. Current doctrine excludes if that exchange was not voluntary, if it was coerced, the fruits as well. Amar, outrageously perhaps, but Amar would not exclude the fruits. It's connected to the exclusionary rule because the fruits are reliable evidence in a way that witnessing might not be. This helps explain the Schmerber case, where we take the person's very body and use his very blood, compelled, against him to prove his guilt because blood is reliable in a way that words are not. Alan resists this. And he offers some textual critiques, but it's textually a permissible reading. It's not the only reading. So why does he resist it? And this book really was a provocation for me. It has many brilliant flashes, and there is a great book also on the Fifth Amendment by Dean Griswold of this place. The great Henry Friendly from this law school also wrote compellingly on the issue. So, and here were three hypotheses, because I learned a ton, and I thought I had read almost everything on the topic, and I just learned a ton from this, and he wears his erudition very lightly. You can read this in 2 hours, and you could spend 2 years thinking about it and still keep thinking. So here's one thing that he said, and it was very interesting. I'm interested in, and in Amar's world, guilty defendants aren't helped so much, but innocent defendants are actually better off. Here's why. So Smith is on trial. He knows Jones did it. He wants to put Jones on the stand, and right now he's not quite allowed to, because if Jones takes the stand, you've got to give him immunity. That's Fruit's immunity as well. It's going to make it difficult for the prosecution to prosecute Jones. Maybe you can't let Smith give Jones an immunity bath. So this is awkward and difficult. So we don't let Smith put Jones on the stand. And Smith is innocent, and we're making the innocent person worse off in a way. Now, Alan doesn't like that, but I think that's actually probably the necessary consequence of overbroad exclusion, Fruit's exclusion. So why does he have this resistance? Well, here's one interesting thing that he said. He said, under traditional Jewish law, for example, no person could voluntarily incriminate himself. And then he says again, and this is, and in the Jewish tradition, it actually may not just be about innocent people being saved from erroneous conviction. There's an idea under Jewish law, confessions are never admissible against a criminal defendant, even if they're voluntary. The prohibition isn't against compulsion, it's against self-incrimination. So I want to hear more about this, because I remember actually, we once had a conversation about this in a train station. I said, this is I think actually Jewish law has a different understanding than mine. But saying all that from someone who's not inside the Jewish tradition ranges somewhere between possibly anti-Semitic and at the very least, chutzpah. Alan can write about this, and he's teed it up, and I think it's very interesting, the trade-off between protecting innocent defendants and guilty defendants, because there actually may be a trade-off here. Criminal defense attorneys, most defendants are guilty, and Alan is a very successful criminal defense attorney. Maybe I protect a few innocent defendants, but I hurt more guilty defendants because there's just more of them. This is a theme of Alan's book, The Devil's Advocate. The Advocate's Devil, excuse me. The tension between protection of the guilty, sometimes at the expense of the innocent. This is a theme that concerns him. So I want to hear a little bit more about that final thought. The law in America actually did once embrace my view of merely excluding the words and not the fruit. A man named Abraham Lincoln actually signed into law an Amar-like statute. Alan has written compellingly about Jefferson. Madison is featured in this book. Haven't heard as much from Alan on Lincoln. So more to do, Alan, and I want to hear from you. Okay, thank you.
Alan, it's also to your credit that the only person on this group of people who doesn't identify as Jewish and who wears a beard is the only person who's quoted the Torah at us so far. So that's good, Akhil. Dean Minow, please.
So one of the prerogatives of being dean is that every now and then you get to say, I want to do this. And so of all the panels that are going to take place today, I'll be on several as moderator, but this is the one I wanted to be on. And why is that? Because I have many, many personal stories to say about Alan that, of course, I won't say, like how when I was clerking for David Bazelon and he said my most brilliant clerk was Alan Dershowitz, and I won't talk about that. And I won't talk about how Alan partly was one of the reasons who convinced me to come here, and I didn't know a soul. And Alan was like my big brother, taking care of me then. And then he met Carolyn, and life got better completely, I could see. And I won't talk about our Talmud class together, and I won't talk about all of those things because I want to talk about Alan as a scholar. Alan does the most important thing that a scholar can do. Alan asks good questions. Alan asks questions that make people think. Does the First Amendment give people a right to go nude? Did the Declaration of Independence create a Christian state? Does being a victim of the Holocaust justify revenge? Does being a victim justify excusing people from responsibility? Is there sexual McCarthyism in America? Will we have less torture if we have torture warrants than if we don't? Alan's questions focus attention on what a lot of people don't want to think about. But by framing the questions the way that he does, that's number one, he actually puts on the agenda the hard questions and insists that we study them. The next thing that Alan does as a scholar is he takes positions. This is something I'm not very good at. I'm a middle child. Alan is excellent at this. Alan takes a position, he drives it into the ground, but in so doing, you see the layers and the layers and the layers. And so the torture warrant, a subject which actually has already been raised in some ways, probably the thing I disagree with Alan about the most. Nonetheless, it's the most generous effort to engage with the opposite positions while examining the case for his own that I've ever seen. Similarly, and it's connected to taking positions, Alan is a scholar who's in dialogue. It's never alone. It's always engaged. And so I'm so glad, actually, to hear both of the justices describe the dialogue that Alan has had with the Israel Supreme Court, because it is that dialogue that is characteristic of his work. And it, again, is generous. It is, again, giving the best version of the other point of view, not the worst version, the best version, which, again, is the exemplification of the scholarly tool, best of all. Just two more. I knew I'd be last, so I'm going to be brief. Alan, you may know, among the 30-some-odd books, there are a couple novels. And some would say, so those aren't scholarly. Wrong. These are incredibly scholarly books. They, again, ask really good and tough questions, and they convey the questions in a way that are haunting and memorable, the same way that his teaching does the same thing. And so it's a form of dialogue, and one more thing, it's a form of engaging with humanity in all of its imperfections. So you can't understand Alan without putting together the novels along with books where he actually offers himself as a defense attorney for the people in the Bible, which they need because, Cain and Abel, they need some lawyers, right? But he does the same thing in his novels that he does in his scholarship. He paints people vividly with their imperfections, and that is the world that we have to live in. So, Alan, justice shalt thou pursue. You are restless, you are a wrestler, you put questions on the table and you wrestle with them and you invite everyone else to do the same. You are a scholar's scholar, and I salute you.
Alan, this wouldn't be your conference if you didn't have a chance to respond, so please join us, and you can have my seat if you like. Or
First of all, thank you so much for the provocative comments. I wish I had 6 hours to take each of you on and rebut and respond. I was asked today in an interview what I wanted my tombstone to say, and Martha, you anticipated it, because what I said was, he asked hard questions and he refused to accept simple answers. And I think the questions that I addressed today and have gotten no simple answers at all. They've gotten extraordinarily complex answers. And I want to throw just one question back at each of my interlocutors. Of course, I have enormous respect for President Barak's decision. And had I been a justice, I would have joined it. As a justice, I would have agreed with you. I think an academic has a different role as a justice. A justice has to resolve, has to decide. And if I were ever asked to make a decision on the issue, I would probably reject my torture warrant notion, but I wouldn't want to censor it as a continuing source of debate. And some of the academy try to censor me, literally. Professor Posner really said there was no room for this in the debate, and many others did the same thing. I was called Torquemada Dershowitz. People confused my support for torture warrants with my support for torture, which doesn't exist. I'm completely opposed to it. And so my question to Professor Judge Barak, whose friendship I share and admire, is this. You talk about the necessity defense, and you too have just thrown it out there as an idea. Let me just give you a fact why I think it's not a good idea. I think the necessity defense and giving individuals the right to make personal decisions as you do it should be reserved for extraordinary, unpredictable situations. We all studied in first-year criminal law, eating the cabin boy on the boat or the Spelunkian explorers. Those are non-recurring problems that we can't predict, whereas the need to use extraordinary methods of interrogation in the context of a ticking bomb is eminently predictable. It will happen someday. We know about it. Therefore, to take it out of the democratic process and put it into a process of leaving it to each individual to make the decision, I think undercuts democracy a little bit, and to to vary the question and throw it back to President Beiniesh, what President Beiniesh has suggested essentially, and I think quite brilliantly, is a torture warrant directed to the head of the security service. What you're saying is the alleged torturer has to get permission from or approval from the superior, the head of the security service. That is a warrant, in my view. That's simply going up the next step and getting approval. And what I understand, of course, is judges don't want to be the ones issuing the warrants. I wouldn't want to issue a torture warrant if I were a judge either. But I think in a democracy, judges have to get their hands dirty. If they're prepared to sit in judgment over somebody's actions, then if they're given the problem in advance, they have to give a declaratory judgment, an anticipatory solution. Otherwise, I think that becomes a cop-out. So those are at least my two hard questions. I think on balance, as a judge, I would agree with both of you. I think it's the safest, best, the most judicial resolution, but I think the debate has to continue. Now, the interesting thing about both Professor Mnookin and Feldman is you probably don't know that Professor Feldman has also written about the subject. He wrote a very brilliant op-ed piece in the New York Times dealing with the issue of the changing nature of institutional anti-Semitism and how the WASP culture basically gave up their power to the Jews. I have a different view of that because I lived through it. I was turned down by 32 out of 32 Wall Street firms, and because I was Jewish, and I don't think they particularly gave it up voluntarily. What happened is, in the nature of democracy, I think Jews became judges, they became influential. It therefore became important for law firms to begin to hire Jews who could identify with the judges and make powerful arguments in front of the judges. Same thing is true on the faculty as well. But I think that both of you put the question very dramatically. For me, again, there's no answer. When Professor Mnookin said my three solutions, one, go to shul, that was, just, it's not going to happen. It could be interesting, but it's just not going to happen to most Americans. Second is go to Israel. It's not going to happen. And the third really is learn to deal with change. What I reject completely in my book is what I call the Tsurist theory of Jewish survival, that the only way for Jews to survive is to have trouble, to have external threats, whether it's the external threats to Israel. I, myself, would rather see the external threats disappear. I would like to see Israel a boring Switzerland that simply nobody cares about anymore, and including American Jews. And, I think that the sense of where Judaism has come over the past thousands of years is to a situation where it doesn't know how to adapt to its own success. Fortunately, Israel has saved it from that, because Israel is today an underdog country. Though it's the most powerful militarily in the Middle East, it still faces forces from outside. So it gives us, people like us, an excuse to still cling to our Jewish heritage, because we can say we're defending the underdog. But that's not a long-term solution to an enduring problem. And then finally, to my dear friend Akhil, you'll never persuade me, nor will Dorit, on the exclusionary rule. I think in both cases, the better 10 guilty than one innocent be wrongly confined, and we need to have deterrence. But I want to assure you of one thing. My next book is a book, it's called Abraham, about the character Abraham in the Bible, the first but certainly not the last Jewish lawyer. And it goes from Abraham to Abraham Lincoln. And I do a lot about Abraham Lincoln. It really, I don't want to sound like I'm too immodest. I remember having a conversation with President Obama, name dropping, recently, in which he asked me how the autobiography is going, and I said, I'm having trouble balancing truth with modesty. And he says, Dershowitz, modesty? I never heard those two words used together. So immodestly, I do, the book about Abraham is from the patriarch to Abraham Lincoln. My name is Avraham. So I use myself as a metaphor for the current generation of lawyers and Jewish lawyers. So I just thank you so much, and let's continue the dialogue. We will never agree about everything, but we will always agree, I think, that asking hard questions is the essence of provoking at least an approach to truth. You know, I don't think truth is a noun, I think it's a verb. And I think that we're all engaged in the truthing process. And thank you so much for helping me think about a lot of my ideas. And I'll go home and start thinking and writing about all of them. Thank you very much.
Alan, you could retire from full-time teaching at a university, but you can't retire from being Alan Dershowitz, and we know you won't. So thank you very much.
We will now go to the next panel.